And so, okay, we filed an answer or a motion and we've gotten through that process. Then what happens next?
So this is where litigation sometimes gets a little nitty gritty. This next, we proceed through what's called discovery. And discovery involves a whole bunch of things. It involves exchanging documents, sending requests, sending interrogatories, which are basically a list of questions each party wants the other party to respond to. And then frequently we get into depositions, which might be like you're used to seeing on TV or in a movie or sometimes these days on the news, where you go in a conference room with your lawyer and their lawyer, and you answer questions under oath before a court reporter. This is, I like to explain this is sort of like a preview so that the other side or your attorney can see what a witness would testify to on the stand should the case progress to a trial.
Just had this conversation the other day with a friend who was going to be deposed for a corporate thing. And they were like, but it's so long ago. Like, how am I supposed to remember this stuff? It's when you're in the deposition. Do you have to know like everything? Or can you say, like, I don't know, that was 3 years ago?
Oh, I don't recall is a perfectly acceptable answer. You don't want to go out on a limb and guess or make assumptions. While they're saying this happened, it might have happened. I tell people if you don't know what they're asking, ask to repeat the question. If you don't remember what they're asking about, tell them you don't remember. Obviously, when you're under oath, honesty is the best policy, and sometimes litigation doesn't happen until 1 to 5 years later. So it's not expected that you have a photographic or a videographic memory.
Yeah, and one of the things that I think we like to tell our clients is the job of the person opposing you is to ask you questions and make you feel a little comfortable because they're just trying to get to the root of what happened. It doesn't mean you did anything wrong. They just honestly weren't there, right? As attorneys, we like to know everything that's going on, but we weren't there when whatever happened that was allegedly wrong happens. We have to ask questions.
Yeah, I mean, we as attorneys are at the mercy of what our clients tell them, right? So a plaintiff's attorney is trying to verify their client's story the same way we're trying to verify yours and make sure that if you're in a courtroom, that there's no surprises. So in order to help you with this, if we're your attorneys do deposition prep, we come up with some questions that we expect might be asked, and we go over it with you ahead of time so that you're a little bit more comfortable. But again, it's a totally unnatural feeling unless you're someone who unfortunately has been sued quite a bit.
And hopefully not. Hopefully we don't have any of those
Right,
folks.
exactly.
Yeah. Okay. And so, like, how long are we talking? So you gave us a very clear timeline. It's 28 days to answer, but this discovery seems like an amoeba. Like we don't really know what the timeline is.
Well, once you get a discovery request, you have a certain number of days to respond, and then there's usually back and forth between the lawyers. They think you didn't give enough information, you think you provided enough information. So this is kind of where it gets into the sort of slog of litigation. We always try to be upfront with people and assess a case at the outset and say, listen, maybe this is something we don't want to progress to discovery, or if it does progress to discovery, this is where it gets a little lengthy and might cost you more money. So if this is something you want to consider settling, or if we file a motion to dismiss, then we wait to hear on that before we start engaging in discovery. There's really sort of a number of different paths things can go.